In this section, we're going to talk about custody in Minnesota. We're going to talk about the statutory definition and how the courts view custody designations. So, first, there's two kinds of custody in Minnesota. There's legal custody and physical custody. And let's start with legal custody. Now, the defining statute is Minnesota Statute 518.17. And in Minnesota, legal custody is presumed to be joint. The courts figure that both of you really care about your children and that both of you are able to make those important decisions regarding the major things in your child's life. Specifically, they're talking about health, education, and religion. And so, to the extent that the two of you have agreements regarding those, then there shouldn't be any issue, and you should just simply be saying that there's going to be joint legal custody. And I suppose, if you want to talk about some special considerations is if you have differences, huge differences regarding religion, and if you do have huge differences regarding religion, the one thing I want to tell you is that the courts are very keen that, let's say, you're Catholic and you want the kids to go to church with you every Sunday. If it's your other spouse's parenting time, the courts generally think that the children, it's more important that they're with that parent than they are attending religious education. So I just want to give you that caveat. It might save some negotiations later on. But another one is in terms of education, just understand that now it has become an issue of where are the children, going to have their primary home, because that's going to be determinative of where the children are going to be going to school, which is a joint legal custody decision. And obviously, health issues. If the two of you have huge issues regarding vaccinations, that's an issue that you may need to talk to the family physician or other healthcare professional, or talk about in mediation prior to reaching some agreements. I just want to raise it that the statutory presumption is it's going to be joint, and if there are reasons, they have to be really good reasons for it not to be joint. Although I will say that if there is domestic violence in the relationship, the statutory presumption actually moves to the victim of domestic violence to receive sole legal custody of the children, unless it's in the best interest of the children for it to be another way. So let's talk about physical custody in Minnesota. Again, the same statute, 518.17, and you can look that up on Google. And it's gotten a little clouded. Historically speaking, it used to be that if you had custody of the minor children, then you received child support. And so it was really important as to who had physical custody of the children. But that all changed in 2008. And so since then, and that now was a long time ago, and the courts generally recognize that they want parents to co-parent. And so I've had more than one judge routinely say that what is really important is the parenting time with the minor children. And child support now is based on the amount of parenting time you have. And we're going to go deeper into that in the next section. But I just simply want to say that understand that physical custody is not as important anymore. And even if you have physical custody of the children, it still isn't going to matter in terms of being able to move out of state or in being able to get child support. Another important point to make is because of the fact that physical custody isn't that important anymore, designating someone with physical custody, that they actually have a different statute that talks about simply setting up a parenting plan and not designating who has physical custody. You still want to designate who has the primary home for the children, simply to receive the report cards and the health insurance and those kind of things. But that can be done mutually, and you definitely need to have a discussion about where it makes the most sense. But there is a caveat even on that statute, and it says that even if you don't say what physical custody here in Minnesota, if the two of you move out of state, you need to say what custody designation it would be if you move out of state. It's just a little carve out that has to be done. But that brings up another interesting point, and that is Minnesota Statute 518.175, Subdivision 3, moves out of state. And the interesting thing about moves out of state, it used to be, again, if you had custody of the children, you were free to move out of state, even though it would severely affect the parenting time rights of the other spouse. Well, that's no longer true. And again, that was changed in around 2009. So the courts are more protective of the other parent's relationship with the children, recognizing that, again, children need both parents. They need time with both parents. So what they've done is they've created this specific statute related to if you want to move out of state, you have to have what's called a modified best interest of the children standard that the courts are going to use in determining whether it's in the best interest of the children to move out of state with you. You can always move out of state, but it could actually bring about a change in custody of the children to the other parent. So it is something to think about as a part of your divorce. Now, the interesting thing is this statute doesn't actually take effect until after the judgment and decree is signed. So if it is going to be an issue that you definitely want to be moving, you need to have that discussion prior to signing the divorce decree and make sure that agreement is included as a part of the judgment and decree. Otherwise, fully expect that you're going to be staying here with the kids. If you want to stay with the kids, you're stuck in Minnesota till they're 18, or unless you have a really good reason and convince the court that it's in the children's best interest for the move. I just want you to be aware of that. Then the other issue I want to talk about related to custody is modifications of custody. And I know you're saying, Susan, why are you bringing it up now? We're just working on our divorce. Well, the reason is I get an awful lot of people who say, at what age can children decide that now they want to live with the other parent? And I want you to know that there is nothing in statute that says that at this age, children get to change what parent they want to live with. And so I just want you to be aware of the statute, modification of custody statute, which is Minnesota Statute 518.18. And that statute basically says that there's 4 ways that you can modify custody of the minor children. And one is by agreement of the parties. Obviously, that's the easiest. And if you are going to modify custody that way, I do recommend that you have a written agreement because it will affect child support. Then there is the second way to do it is you have to show, and this is the legal language, that the child has been integrated into the home of the petitioner with the permission of the other parent. Now, that situation is, I've seen it a couple different ways in my practice. One was there was a mom, and she had remarried, and her husband was in the service. And so the child had to remain with dad here in Minnesota while mom went off to another state with her new husband. And the problem came is that she just thought she would be able to resume custody of the child once they now moved back to the States, and she wanted to just take the child back. Well, father brought a motion, and he was successful in that, in saying that the child had been integrated into his home with mom's permission. And so she basically lost permanent custody of the child that way. And the way I've also seen it is I had a case where there was a 14-year-old boy, and he was being such a little jerk that his mom said, "You're going to go live with your dad." And dad lived in another county, and so dad said, sure. And he went and he enrolled the boy in school in his county, got him a dog, got him a bike, got him his own room. And 6 months later, mom said she realized it was going to affect child support, so she said, oh, I want him back. And we brought the motion and were successful in finding that, again, the child had been integrated into my client's home with the permission of the other parent. And you notice it is a fact situation, but I simply want you to be aware of that. even in these discussions regarding your divorce. Then the third way that it can happen, and the more usual way, is the child's present environment may endanger the child's physical or emotional health or impair the child's emotional development. Now that's quite a handful, and I just want you to be aware that it's that level of seriousness that the court is going to, that's the only time the court's going to consider a change of custody of the minor child. And in addition to that, you also have to show that it is in the child's best interest and that it is better for the child for the change of custody than not. So it's not just showing the endangerment. And the cases, from my cases, I had a situation where dad and the child went and got into it, and understand that particular child was now 17 and outweighed dad. And so they got into a hustle, and so the child went to live at mom's. Well, mom, ironically, her boyfriend was dad's brother. It was a weird situation, folks. But he was a bigger SOB than my client. And so we were able to defeat their motion for change of custody because it would actually have been less advantageous for the child to go in the new family situation than it was for the child to remain in the current situation, hopefully with some counseling and working out the problems between dad and son. But I just want you to be aware that you're looking at an endangerment statute standard for that to occur. Then the only other way that the courts will look at considering a change of custody of the children is if there is a persistent and willful denial or interference with parenting time. And that is where one parent simply says, no, I'm not going to I'm not going to let you see the kids. And it has to be persistent and willful. And again, what you notice in all four of these situations is they are fact specific. And I just want you to be aware of, they're not easy peasy to get. You've got a initial hearing where you go and you bring your motion in affidavit, and the court has to make a decision that based on the information provided, the court would be more likely than not to grant you the relief. And then that only sets it on for an evidentiary hearing. So they can be very expensive, and that's why I want you to be aware of it now. And I want you to be making your initial decisions regarding custody and parenting time based on the best interests of your children, and hopefully with some flexibility, so neither of you will need to bring any modification motions following your divorce. Finally, I want to just tell you that as parents with minor children, most counties will expect you to take a co-parenting class. And this isn't how to, live together. This is how you can co-parent apart. And it is a statutory requirement to receive a divorce. There's a few counties that won't even hear your final divorce. So you could file for a divorce and they say, no, we're not going to do this until you take that parenting class. So I just want you to be aware of the fact that there is a statutory requirement and each county reviews it different. And so you want to make sure, and it will be in your initial paperwork that you receive from the court when you file your divorce. So that's all on custody, and that's all in this section. Please take care.